Hello, good morning, and happy Saturday. My name is Meghan Maes, and this is Being Civil in Minnesota. I'm a lawyer in the state of Minnesota, and I practice mostly in the areas of family law and crime victim advocacy. I come here every Saturday to talk about the court process and issues impacting families and individuals in the state of Minnesota. This is not intended to be legal advice, nor does this make me your lawyer. But this is, I hope to be a place where people can ask questions and get answers to normal questions that people have about the court process that may not be involved with it on a daily basis. Um, Thanks to everybody who's been joining the group. Hi, good morning, Vanessa. Thanks to everybody who's joined the group and invited members. We almost have 300 members, and I think it's been a really good dialogue and a good place for people to sort of kind of see if their situation is typical or if their situation maybe needs a little bit more information or advice. So today we are going to talk about how long does the court process take. And in the state of Minnesota and in most jurisdictions, there are certain cases that will get priority on the court's calendar. For about 10 years, I practiced in 17 counties in the state of Minnesota, and I will tell you that in each of those counties, the process is a little bit different. The preferences of the judge, the way that cases are calendared by court administration, that can have an impact. So if there are like speedy trials, for example, in criminal cases, or restraining orders, harassment restraining orders, or orders for protection, those cases are going to get priority on the court's calendar. Some counties only have one judge. So when you can get on the calendar is going to depend a lot on what that judge already has on their calendar. If there is an emergency case, I've had it before where the case that I have, which may not be an emergency, will get bumped for some of those time-sensitive cases. So the court does take those very seriously and will make space in the calendar. Obviously, that can impact other cases. So depending upon the case you have and the priority, that may mean you will get into court a little bit sooner than other cases. As I kind of said, every county has their own processes. There are some counties, hey Jen, good morning, cuz. There are some jurisdictions that, for example, if a divorce or a custody case is started, they will ask the parties to participate in something called an Initial Case Management Conference, which is also referred to as an ICMC. The reasoning, the rationale, from my understanding, is the reason for the Initial Case Management Conferences is to get the parties in the same room to talk about alternative dispute resolutions, ways that we can address some of the conflict, overcome some of the barriers, and put a trajectory on the case. Most of the time when a divorce or a custody action is started, there is uncertainty as to what is the schedule going to be, how are decisions made, and that can be really hard to be able to file a motion for temporary relief if you have to participate in a hearing in advance. I believe there are some ways that you can ask that the court waive that if there are significant safety concerns or other emergencies. But if the county does want you to have an ICMC first, they're likely going to want you to follow that process. What also can impact how long your court case can take is if you do need a motion for temporary relief. Are there issues like occupancy of the home or temporary child support or parenting time, medical decisions need to be decided that can't wait for either a trial or, something down the road? In those cases, you could file a motion for temporary relief. You will need to serve that motion weeks in advance. So it's not like you can get a hearing next week unless there's an emergency. So calling and getting a hearing date is going to be important, and that'll tell you when your motion paperwork needs to be submitted by. Once a court does hear that motion, the judge has 90 days to make a decision. In my experience, most of the time judges do not want to wait the 90 days, mostly because in the cases I deal with, they're involving kiddos, and certainty, stability, security, all those things are things that the court wants to support and help families. And then, even if you still can't agree, you've tried alternative dispute resolution, you've gotten your temporary motion, you still can't come to a decision about long-term or permanent issues, then you go to trial. And how long your trial can take depends on how much evidence you have, how many witnesses you have, and how many issues you have left that you can't decide. Once all the trial dates are done, again, the record will close and the judge will again have 90 days to make a decision. Once that decision is made, the parties have the right to an appeal. And that appeal process can take years. But if you're not appealing it, then your decision would sort of be the end of that case. Does that mean you can never go back to court? Not necessarily. There are ways to go back to court if there's a change in circumstance or an emergency. In custody and parenting time, you're looking for things like a willful and persistent interference or failure to follow the parenting time schedule, or something that is really going to negatively impact the kiddo's mental health or development. So someone asked in the group today, they've been having a court case that is kind of going on and on and on, and started in May and is still going on. And they wanted to know, what can they do to get the other side to respond or to participate? They're almost close to an agreement, but either the other party or the other side is dragging their feet. A couple things that I have found to be helpful is getting a status conference, contacting court administration and requesting a status conference with the judge. Let the judge know what's going on. Judges don't typically enjoy unreasonable delay. And so there may be some encouragement that the court can do to help kind of keep an eye on the case so it doesn't fall off of their radar. Another option is to request a scheduling conference. And at a scheduling conference, you're going to be putting deadlines, dates, trial on the calendar. Once there are things on the calendar, it's a lot harder to drag your feet, because you're going to have to either put your money where your mouth is and actively engage in those settlement discussions and come to an agreement, or you're going to have to prepare for trial. And so trial can be very expensive and very time consuming. It can be a really motivating factor if a trial date is on the calendar, that there's only a certain amount of time that the parties can work together before the decision will be out of their hands. So when I created this event today, I had asked people how long their court cases took. I'm always interested in learning about other people's experiences in the court process. It helps me understand how to best advocate for my clients and things that I can do to help clients navigate the court system. I appreciate everybody's time. The sun's right about to come out. I've got some last minute tomatoes out of my garden to rescue before the frost. Appreciate you guys stopping by. If you have any questions, pop them in on the chat or post them in the group, and I will answer them next Saturday. Take care, everyone. Have a great weekend.